Thank you, Chair. I will then continue with the charges, reading out the charges in relation to Mr. Matumba. Events on 9 June 2022. It is alleged that you are guilty. I think I will skip that. It's not necessary for me to repeat that. You willfully refused and or failed to obey Rule 69A of the Rules of the National Assembly when you deliberately created serious disorder or disruption in the House. Charge 2. You contravened Section 7A when you deliberately breached Rule 69C, when you repeatedly undermined and disregarded the authority of the presiding officer and repeatedly refused to obey rulings of the presiding officer, and or you repeatedly disrespected her and interrupted her while the latter was addressing the House. Charge 3. You contravened Section 7A in that you further contravened Rule 69F, where you behaved in a manner which was detrimental to the dignity, decorum, and orderly procedure of the House. I will then move on to charges under the events of 10 June 2022. Charge 1. You willfully refused and or failed to obey Rule 92(6), 8, and 9 when you refused to accept the ruling of the presiding officer that no points of order may be raised, and you deliberately continue to disrupt the proceedings of the House by raising points of order that do not comply with the rules. Your conduct disrupted the proceedings of the National Assembly. Charge 2. You willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and disruption of the House when you refused to obey and respect the authority of the Chair. Charge 3. You willfully refused and or failed to obey Rule 69B when you physically intervened and physically prevented and or obstructed and or hindered your removal from the House after the presiding officer ruled that you leave the House. You physically pushed the sergeant at arms away when he approached you to leave the House. Charge 4. You willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey the rulings of the presiding officer, and you repeatedly disrespected and or interrupted her while the latter was addressing the House. Charge 5. You contravened and failed to obey Rule 69F when you behaved in a manner which was seriously detrimental of the dignity, decorum, and orderly procedure of the House. I now move on to Ms. Mafanya. In relation to 9 June 2022, you willfully refused and or failed to obey Rule 92(8) and 9 of the Rules of the National Assembly when you continuously proceeded to raise a point of order when the presiding officer had ruled that no member may raise a point of order again until the President had delivered his budget speech. Charge 2. You willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and disruption in the House, when you refused to obey the authority of the presiding officer when she ruled on the points of order. Charge 3. You willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey her rulings, and you disrespected and continuously interrupted the presiding officer while she addressed the House. Charge 4. You willfully refused and or failed to obey Rule 69F when you behaved in a manner which was seriously detrimental of the dignity, decorum, and orderly procedure of the House. I now move on to Ms. Babalwa Matulelwa in relation to 9 June 2022. You willfully refused and or failed to obey Rule 92(8) and sub 9 when you continue to raise a point of order despite the fact that the presiding officer had ruled that no points of order would be allowed until the President delivered his budget speech. Charge 2, you willfully refused and or failed to obey Rule 69D when you made serious allegations against the President by calling him a criminal without adequate substantiation or following the correct procedure. Charge 3, you willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and you repeatedly refused to obey the ruling of the presiding officer when she instructed you to withdraw the statement that the President was a criminal. Charge 4, you contravened Section 7A in that you willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and disruption in the House. Charge 5, you willfully refused and or failed to obey Rule 69F when you acted in a manner which was seriously detrimental of the dignity, decorum, and orderly procedure of the House. Charge 6, you willfully refused and or failed to obey Rule 71, read with Rule 72, when the presiding officer ordered you to leave the chamber immediately and you refused to do so. You again refused to leave the chamber after the Sergeant-at-Arms requested you to do so. You were then removed by the Parliamentary Protection Services, the PPS, after they were instructed to remove you by the presiding officer. Charge 7, you willfully refused and or failed to obey Rule 73(4) and 5 when you refused to leave the chamber when requested to do so by the Sergeant-at-Arms and when you physically resisted and physically fought with members of the PPS when they tried to remove you from the chamber. Now the charges relating to the events on the 10th of June. Charge 1, you willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and or disruption in the House. Charge 2, you willfully refused and or failed to obey Rule 69B when you physically intervened and prevented and or obstructed and or hindered the removal of EFF members Ms. Chirwa and Mr. Tambo by the PPS. Charge 3, you willfully refused and or failed to obey Rule 69E when you used violence against the PPS who were called in to remove you from the chamber. You physically fought with the PPS members and pushed them out of the way to stop them from removing you from the chamber. Charge 4, you willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and disruption in the House. Charge 5, you willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and refused to obey the rulings of the presiding officer, and or you disrespected and interrupted the presiding officer while she addressed the House. Charge 6, you willfully refused and or failed to obey Rule 69F when you acted in a manner which was seriously detrimental to the dignity, decorum, and orderly procedure of the House. Charge 7, you willfully refused and or failed to obey Rule 64D when you crossed the floor of the House in front of the benches and when the mace was still in the House. Your conduct improperly interfered with or impeded the exercise or performance by the House of its authority and functions. Chair, I now will deal with the charges relating to Ms. Marie. She is only charged in relation to the events on 10 June 2022. Just give me one moment, please. that you willfully refused and or failed to obey Rule 69A when you created serious disruption and or disorder in the House, when you continued to shout at the presiding officer. Charge 2, you contravened Section 7A in that you willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey rulings of the presiding officer. You repeatedly disrespected and interrupted the presiding officer while she addressed the House. And then charge 3, you willfully refused and or failed to obey Rule 69F when you acted in a manner which was seriously detrimental to the dignity, decorum, and orderly procedure of the House. Charge 4, you willfully refused and or failed to obey Rule 73(1), 2, 4, and 5 in that you refused the instruction of the presiding officer to leave the House. You continued to refuse to leave the House when the Sergeant at Arms requested you to do so. You continued to shout and disrupt the proceedings even when the PPS were called in to remove you from the chamber. I now move to Ms. Chirwa, who is also only charged in relation to the events on 10 June. Charge 1, you willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and or disruption in the House. Charge 2, you willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey rulings of the presiding officer, and you disrespected and continuously interrupted the presiding officer when she addressed the House. You continued to shout at the presiding officer even though she ordered you to leave the House, which you refused to do. Charge 3, you willfully refused and or failed to obey Rule 69F when you acted in a manner seriously detrimental to the dignity, decorum, and orderly procedure of the House. Charge 4, you willfully refused and or failed to obey Rule 69E when you used violence against the PPS when they attempted to remove you from the chamber. You physically fought with the PPS to prevent your removal from the House. You also contravened Rule 73, 4, and 5 when you refused to leave the chamber when requested to do so by the Sergeant at Arms and the PPS. I now read the charges relating to Mr. Tambo. It's also for the 10th of June. Charge 1, you willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and interruption in the House. You contravened Section 7A in that you willfully refused and or failed to obey Rule 69D when you made serious allegations against the President that he was a criminal without adequate substantiation or following the correct procedure. You also continued to disregard the authority and instruction of the presiding officer when she warned you of the relevant rule, which you had breached by calling the President a criminal. Charge 3, you willfully refused and or failed to obey Rule 69C when you undermined the authority of the presiding officer and or repeatedly refused to obey her rulings as the presiding officer, and or you repeatedly disrespected and interrupted her while she addressed the House. Charge 4, you willfully refused and or failed to obey Rule 69A and C when you refused to take your seat after the Speaker repeatedly told you to sit down. Charge 5, you willfully refused and or failed to obey Rule 69F when you behaved in a manner which was seriously detrimental to the dignity, decorum, and orderly procedure of the House. Charge 6, you willfully refused and or failed to obey Rule 73(5) when you physically blocked the Sergeant at Arms from approaching member Ms. Naledi Chirwa who was also asked by the presiding officer to leave the house. By doing so, you physically intervened and prevented and or obstructed and or hindered the removal of Ms. Chirwa from the chamber. Charge 7. You willfully refused and or failed to obey Rule 69E when you physically fought and or physically resisted your removal from the chamber by the PPS, pursuant to an instruction from the presiding officer that you be so removed. You also contravened Rule 73(1), 2, and 5. In relation to Mr. Montwedi, it's also just relating to 10 June 2022, charge 1. You willfully refused and or failed to obey Rule 69A when through your conduct you deliberately created serious disorder and or disruption in the House. Charge 2. You willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey rulings of the presiding officer, and you continuously interrupted the presiding officer when she addressed the House. Charge 3. You willfully refused and or failed to obey Rule 69F when you acted in a manner seriously detrimental to the dignity, decorum, and orderly procedure of the House. Charge 4. You willfully refused and or failed to obey Rule 69E when you fought with the Parliamentary Protection Services when they attempted to remove you from the chamber. You also contravened Rule 92(8) when you refused to leave the chamber when requested to do so by the Sergeant at Arms. Chair, I now move to the charges relating to Ms. Yoliswa Yako, also just in relation to 10 June. Charge 1. You willfully refused and or failed to obey Rule 69A when you deliberately created serious disorder and or disruption in the House. Charge 2. You willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and repeatedly refused to obey her rulings. You repeatedly disrespected and interrupted the presiding officer. Charge 3. You willfully refused and or failed to obey Rule 69F when you behaved in a manner which was seriously detrimental of the dignity, decorum, and orderly procedure of the House. And then the last charge sheet, Madam Chair, is for Ms. Constance Mkontu. I am still instructed that she is still not. Okay. My apologies, Chair. Ms. Mkontu has now joined. The charges relating to her for 10 June, charge 1. You willfully refused and or failed to obey Rule 69C when you repeatedly undermined the authority of the presiding officer and or repeatedly refused to obey rulings of the presiding officer and or you disrespected and interrupted the presiding officer while she addressed the House. Charge 2. You willfully refused and or failed to obey Rule 69F when you acted in a manner which was seriously detrimental of the dignity, decorum, and orderly procedure of the House. Charge 3. You willfully refused and or failed to obey Rule 73(1) when you refused to leave the chamber when ordered to do so by the presiding officer in terms of Rule 70 and or Rule 71. You continue to refuse to leave when the Sergeant at Arms requested you to leave. The presiding officer then instructed the PPS to remove you from the chamber. Charge 4. You willfully refused and or failed to obey Rule 69F when you acted in a manner seriously detrimental to the dignity, decorum, and orderly procedure of the House. Madam Chair, these are the charges in relation to 9 and 10 June 2022.
Thank you, Advocate Golden. Honorable members, I will now recognize each member and request the member to plead to the charges. I will allow for up to 3 minutes. 3 minutes for the members wishing to give a plea explanation an opportunity to do so. Honorable members, if a member pleads guilty to the charges, I will ascertain from the member whether the member admits guilt to the charges as put to him by the initiator. If a member refuses to enter a plea, I must enter a plea of not guilty in respect of that member. I will now start with Honorable Tlangwini. How do you plead to the charges?
Chairperson, you have got a terrible echo, man. Sorry, Chair, point of order. You've got a terrible echo.
Let me switch off the video again. Probably when I switch my video on. Was I audible on the explanation that I gave?
Chairperson, I think you were heard, Chairperson, although there was an echo. Okay. Chairperson, the Advocate Gasabot would like to give an opportunity to say something. Thanks.
Advocate Kasiboto, I'm one of the members. I'm listening. The
Thank you very
members,
much,
how they did. Yes.
Thank you very much for the indulgence, Chairperson. To the best of my recollection, Chairperson, you would have been present as an ordinary member of the committee in the proceedings we had in December in relation to charges that related to some of the EFF members. The first proceedings were represented or Advocate Tembeka Ngaidobi represented the members then, and in the proceedings that followed after, I represented the members. And in both those occasions, we raised points in limine that we invited the then chairperson to convene the committee to deliberate on those points in limine. We intend to do the same now. And we do not do so frivolously because, as you would know, we have every intention of bringing litigation to challenge the processes here. And we've debated and ventilated those issues in those proceedings. But unfortunately, how the law works is if I don't raise them again here in these proceedings, which are different from those ones, then I can't rely on those bases in court if I do not ask that this committee deliberate. And as a secondary issue to that premise is this: we've had engagements, extensive engagements with Mr. Glasso, who then led evidence on behalf of Parliament, where we feel that concessions were made, and properly so. So much so that this committee decided to withdraw the charges against at least one of the members, which was Veronica Mente MP. And we suggest on the basis of that concession and the basis of this committee withdrawing those charges, there's something to be said about the process. And the very challenge we had with Mente MP, which led to this committee exonerating her, appears in these proceedings. Just by way of illustration, the chairperson has charged, not the chairperson, one of my members have been charged with physically stopping PPS from effecting their duties, from crossing the floor, when she was not even present in the building. How can she conceivably be guilty of that charge when she was not even present at the National Assembly? And these are the flaws that we keep talking about. And we are suggesting to this committee, as we did the first time, did the second time, we're doing it for the third time. There must be an independent fact-finding inquiry before you charge members, or at least someone to decide on the facts. What we'll deal with now here is evidence that is baseless. You will not be shown my member being present in the National Assembly, but yet was found guilty of obstructing the PPS when she was not present. So with your indulgence, Chairperson, I ask yet again that these proceedings, in fact, before I make the submissions, because you haven't granted me that indulgence, I'm proposing this, that before the charges are put to my members, that I make these preliminary submissions to you. We adjourn. You make a ruling on my preliminary submissions. If you reject my suggestion, you then put the charges to my member to which they can plead. Thank you for the indulgence, Chair.
Thanks, Advocate Kasiboto. You have indicated here that you would want to put points that you put the last time when we were dealing with other cases or hearings. Now, I wouldn't be able to adjourn for now so that you do that. I'll rather give you that space, that you do that for record purposes, for the reasons that you have indicated of litigation, so that this be on record before I put the charges to the members. So that we have it in record that you put those points to us.
Chairperson.
Yes, sir.
Chair, I'm sorry you were not audible at some places. If you could repeat, and also, Chair, maybe you could give the initiator the opportunity to reply before the committee considers the application.
Okay, I don't know why I was not audible. Let me then give Advocate Golden.
Thank you, Chair. Chair, just on a point of clarity, I would just like to clarify what exactly my learned friend is requesting of the committee. What is the ruling that the committee is supposed to consider? That's my point of clarity. And then point number 2 is that I have read out the charges. I have put the charges to the affected members, and they must now, for good order, and also in terms of the rules, they must now plead to the charges. So whether they agree with the charges or not, whether there is merit in the charges or not, that will follow. But for now, if they disagree, they must plead not guilty. Thank you, Chair.
Thank you, Advocate Golden. I hope I am audible. Advocate Kasiboto. Advocate Golden has outlined the procedure that we are at the members pleading. I have listened to you saying you would want to put some points that you raised in the previous hearing for record purposes. I would want us to agree that we put these members, the charges to the members, and we'll come back to you, give you that space to raise issues that we want to raise for record purposes, because we indicate that this also is part of the litigation hearings that we would want to take.
Thank you, Chairperson. And I'm not certain if the Chairperson is now retracting her initial ruling pursuant to the engagement by the initiator with the Chairperson. I'd want directive in that respect. As I understand it, Chairperson, my suggestion was quite an elementary one, really. It is simply this. We have points in limine, which by definition mean they must be raised before the substantive aspect are dealt with. I mean, it's just a basic principle, really, and I can't believe we're here. All we're simply saying is there are issues, procedural issues we want to raise. It cannot be that simply because we raised them in unrelated matters previously, it must be taken that we've raised them here, because we have not. If the ruling of the Chairperson is that we know what you're going to say, we're not interested in what you have to say as a preliminary or point in limine issue, then say so. Then I wouldn't be bothered to make those representations. But if you allow me to make those representations, then I'll do so now. And then this committee will convene and decide on the preliminary issues as we have in the previous hearings. And if I'm bad, as far as you are concerned on those points, then of course, then we can continue with my members pleading to the charges, which is the second leg of these proceedings, which are substantive in nature. That is all I'm simply asking for. And then the initiator then asks me to respond specifically what it is that I'm asking for. It is that this committee hears me on the preliminary issues. And once you have and you take the view that we must proceed to the substance, only then will the charges be put to my members, and only then will they proceed to give their evidence, or at least hear from Mr. Basso. And I'm asking for your ruling in that respect, Chairperson. Thank you.
Thank you, Advocate Kasiboto. I will give it to honorable members. Honorable members.
Yeah. Chair, if you
Yes,
recall,
sir.
Advocate Golden had asked for clarity, and then she was given the clarity and she would like to respond. Then we can
Okay.
open it up to question. Thank you.
Let's hear your response, Advocate Golden.
Thank you, Madam Chair. I now understand what my learned friend would like to do. He wants to raise in line points. It wasn't very clear at the beginning, and nor was it raised right up front before the charges were put to the members. It ought to have been raised appropriately at that juncture. But that's at this point in time, neither here nor there. I have no difficulty, Chair, if my colleague wants to address certain in-line points to the committee at this juncture. I don't have an objection, and if it pleases the committee, we can adopt that approach. Thank you.
Thank you, Advocate. Honorable members, there's a request to take the points illuminated from Advocate Kasiboto before we put charges to the affected members. This is your hearing. Committee members.
Yes, Chair, I've got my hand up.
Yes, Chair. Honorable Dosi. Then Honorable
Yes, Chair.
Mnenzan.
Can I proceed, Chairperson?
Yes, Honorable Member.
Thanks very much, and good day to all of you. I think it is indeed fair to procedurally allow points in limine to be raised at this stage, and then we can then, as advised, deliberate on them and then proceed with the hearing if that is what we decide. So I'm in agreement that let's allow the representative of the affected members to raise the points.
Thank you, Honorable Dosi. Honorable Mnenzan.
Thanks, Chairperson. I also am tempted to agree. Save this latter part now raised by Honorable Dr. Ndlozi of deliberation. That one now would be subject to what would have been presented. That's my view. But then allowing the situation where there would be a flow of the presentations, avoiding also this hip hopping and these usually stopovers which are just created. Let's allow the presentation as advised by the initiator. We'll take it from there. We'll be advised. Thanks, Chair.
Thank you, Honorable Mnenzan. Honorable members, we will then allow Advocate Kasiboto. Advocate, can I give you 10 minutes to deal with those points, Illumina?
Thank you, Chairperson. Sorry, I could not hear you, Chairperson. How many minutes did you offer me?
10 minutes. I'm looking at my time.
Thank you very much, Chairperson. I am indeed indebted to you. What I intend to do is to go through briefly the substantive submissions that we rely upon as to why this committee should not sit, at least not today, not indefinitely, at least not today. We intend to provide you with the written submissions that I will make reference to now. We are, of course, here seized with charges against my clients who are present before you and charged as read out by the initiator in relation to the proceedings of the 9th and the 10th of the plenary of this House. And we have brought an application at different times which are due to be heard this year, which challenge the constitution and the processes of this committee. What Advocate Mugadobi had done, which was quite efficient, which I repeated the last time I was here and I'm repeating now, what we are suggesting is that there are challenges with the processes of this committee. And just by way of illustration, let me make this point from the start. We have always maintained that there is no reason why the dramatis personae, i.e. the main person in these proceedings, is not availed to my clients for cross-examination. And we made that point in principle the first time. What strengthens our argument is what happened the last time I was here, where there was a whole debate as to what the speaker meant when she said, "You people are disruptive." And the difficulty we had there is Mr. Taso, who led evidence on behalf of Parliament, had said, well, we don't know what the speaker meant. And I had suggested that she clearly meant EFF members. And then MP Dlaguti suggested I was speculating. And I said, of course I'm speculating, but it's a reasonable expectation in the context of the discussion at the time. And the reason the concession was not made that she was referring to the EFF members when she clearly was, is because I had made the point that there's case law that says the speaker is not entitled to deal with members of parliament as a group or as a collective. They represent themselves individually. So you can't have collective punishment. I went further and I made the submission that Ceza MP, for example, had raised a point of order. He had not the entirety of those proceedings raised a point of order that was recognized by the speaker. And then the speaker, in response to him raising a point of order for the very first time, says, I will not allow it because you people are being disruptive. And there's no concession coming from Mr. Basso, and I say in bad faith, because he knew the implications of making that suggestion, which would be not parallel to the case law that he is there as an individual, not as a member of the EFF. It therefore is unfair to preempt what his submission or his point of order would be on the basis of he sits on the EFF benches. For that reason, then we had said that is why the speaker has to be here, so that none of us has to speculate as to what she meant by those words. The speaker was not availed to us. We insist that the speaker must be here again. Why? Because the speaker has charged one of the members saying she was guilty of interrupting PPS from executing its duties. That member was not in the House. Conceptually, how could she then have been guilty of that charge? Only the speaker can answer that question. I'm going to put that question to Mr. Basso in due course. He is going to speculate as to what the speaker had in mind when she kicked out that particular member. He won't give us a definitive answer. And that's the problem with not having the speaker. We, of course, understand the politics of it all. I mean, we all sound people. We understand what is happening here. And I'm saying to you, I will not force this committee to give me the speaker if you don't want to give me the speaker. The alternative to that, which is a fair compromise I would submit, is that let's then let Part B run first. And then the court itself must decide whether the speaker must be here or not. What we've been told in the past is that there was an urgent application in December where the court said these proceedings may continue. It doesn't say the points in law we raise are bad. It did not deal with that question. It simply said, we'll hear you in January. At no point did it say we are wrong by saying the speaker should be here, and we've proven why the speaker needs to be here. Firstly, in relation to Mr. Geza, and secondly, in respect of her kicking out a member and charging her despite her not even being in the house. We say it can't therefore be rational to have the accuser not present. It's the same thing in criminal law. When someone accuses you of theft, it is incumbent on them to avail themselves to give their version and answer to it, and not hide behind paper and legal jargon and seasoned counsel. She must come answer. And if she does not want to answer, then let's let Part B decide in a court of law whether she should be here or not. That's the first reason. The second reason is what we have as paragraph 7 of our submissions, which we'll give to you. It says the Powers and Privileges Committee is a standing committee of Parliament. At present, it is constituted of 13 members of Parliament, 7 of whom are members of the ANC, 2 Democratic Alliance, and 1 who is an EFF member. Now, let's digest what that means in practice. The fact of the matter, which you can't deny, is that the EFF is a political opponent of the ANC. That's just fact. It's the third biggest political party. You can't, as a matter of principle, have political opponents deciding the fate of the political opponents just as a matter of law. This is precisely why you have this concept of recusal of judges. Because if you've got an interest in an outcome, particularly a punitive one, and we see how liberal this committee is in terms of punishing people, draconian if you ask me, was simply because you failed to leave the house, you are sanctioned for an entire month not to represent your constituents. In some instances, your salaries are docked. In some instances, you're asked to embarrass yourself by addressing an entire parliament, apologizing to the nation. That is quite extensive. And I'm saying if those are the measures that you're prepared to meter out, in some instances, not in isolation, but as a combination of various punishments, that extensive punishment surely cannot be at the discretion of political opponents of the EFF or the DA or the IFP for the matter, just as a matter of principle. And I'm not asking you to even make a determination as to whether I'm right or wrong, because in fairness to you, these are issues that are to be ventilated in a court of law by properly qualified persons, i.e. judges. We say there is simply no prejudice to this committee, particularly in light of the fact that we've now agreed that we'll not finish tomorrow. We'll still come back perhaps in February, March, April, who knows. And we are saying if these matters are to be heard now in January or early February, then what's the harm in allowing that process to run and then come back at a later stage if we lose at Part B? What is the conceptual difficulty for the committee to suspend these proceedings so that the court can fully ventilate on these issues I raise? And that will happen before even sit for the upcoming session, the second session, whose dates have not even been agreed to date. So again, I ask rhetorically, I must be frank, what is the conceptual difficulty with postponing these hearings?
You have a minute, advocate, to wrap up.
Thank you, Chairperson. I'd intended to raise more points, but I will abide at the risk of being sanctioned with the ruling of the Speaker that I only have a minute left. I suppose I'll reserve if we proceed with these or the rest of my submissions when I deal with Mr. Glass in cross-examination, if we get to that. With that being said, Chairperson, I think that's the totality, at least for now, as to why we're suggesting that these hearings must be pended, and I'm subjected to the ruling of this committee, and I presume you will take an adjournment to consider them. Thank you, Chairperson.
Thank you, advocate. Honorable members, I'm giving you an opportunity to deal with the points that has been raised as points illuminated by advocate Kasibot.
Chair.
Honorable Mlenzana.
Sorry, Chair.
Oh, yes, sir.
People that would like to respond.
Okay.
Okay.
Let's give her a chance.
Thank you, Chair. Just before the committee deliberates on its ruling, I just have the following very short points to make. So I hear that Advocate Kasibota has prepared written submissions in relation to his in limine points, which he has just addressed to the committee. I was not aware, nor was I informed, that the EFF's legal team were going to take legal points in limine in nature today, and nor was I given a copy of the written submissions to which Advocate Kasibota has now referred. I place on record that it would be inappropriate and indeed proper to forewarn me of this, and then also to send me ahead of the hearing so as not to take me by surprise of the written submissions. That's point number one. Point number two, and it's really just a couple of points in relation to the merits of the in limine points which my learned friend has just raised. Chair and committee, you will recall that indeed several of these points or submissions were made when we dealt with the hearing related to 30 August 2022. That hearing was finalized on the 14th of December of last year. Now, the issue of the speaker, Madam Chair, is this. I have made it very clear right up front. It's also been referred to in the various correspondence that we have written to the attorney of the EFF that we do not intend to call the speaker to prove the charges or allegations against the relevant EFF members. And the reason for that is quite simple. In my view, we do not need the evidence of the speaker to prove the charges against the members. We will almost exclusively rely, well, not exclusively, but largely rely on the video recording evidence of the 9th and the 10th of June, 2022, the proceedings in the National Assembly. I will lead the evidence of Mr. Kraso, who is our only witness at this stage. And then I will also, at the appropriate time, place on the record the affidavits of the other members or other witnesses, which we do not intend to call to lead viva voce evidence. So the short of it is that I do not need the evidence of the speaker to prove the charges against the relevant members. And as I've made the point in the hearing in December, I make it again. I must fall and stand by the evidence that I lead in this hearing. And that is a very basic principle, one which my learned friend understands. Now, in relation to the request that the committee postpone the hearing in order to allow for the Part B application, which the relevant EFF members have launched in the Western Cape High Court, if I'm not mistaken, it was in December of last year, for that process and that matter to run its course. Part B, I assume, I am not counsel in that matter, but if my memory serves me right, Part B is the review application and the constitutional challenge which Advocate Kasibota has referred to. Now, the urgent application was dismissed. This is now in relation to the relevant EFF members and the application where they wanted to interdict the continuation of the hearings. That application, Chair and committee, was dismissed by the Western Cape High Court, and the learned judge in that matter ordered that these hearings may proceed. I also mention, and again, I rely completely on memory, that the issue of the calling of the speaker as a witness was a central feature in that application as it is in the review application. So this was an issue that was considered by the judge who heard the interdict application. And again, that application was dismissed, which cleared the way for these hearings to continue. So my submission is that there is absolutely no basis in law or for any other reason for the committee to suspend this hearing and to postpone this hearing in order to allow for the Part B review application to proceed in the High Court. Just a word of caution to you, Chair, and the committee. Practically speaking, if that were to be allowed, and if the committee were to postpone and suspend these proceedings, then it would mean that the Part B application would run at its own pace and on its own time. We have no idea when that application will be finally determined. It will, needless to state, and again I speak of experience, it could take more than a year to be finally determined, if not 2. So my final submissions are that there is absolutely no basis for the in limine points. There certainly is no basis to suspend these proceedings to allow the High Court litigation to run its course. And I ask that the in limine objections be dismissed and that the hearing continue on the merits. Thank you, Chair. Thank you, Committee.
Chair, I'm sorry for coming in. Ms. Advocate Gasiboto would like to come in, I think, to respond to what Advocate Collett has said. Thanks, Mike.
I promise I'll be brief, Chair. It's just in response to what has been raised, and it's to give you answers that presumably don't exist. I promise I will not take 2 minutes of your time if you'll allow me, Chair. It's just to
You have
assist
a
the-
minute, Advocate Gasiboto, because I want to give honorable members of this committee.
Thank you, Chairperson. This is just to assist the committee. So the issue being raised is that we don't know when this matter will be heard in court. These issues I'm raising will be heard on Thursday, this Thursday, in the Western Cape High Court. So it's not an indeterminate period of time. We are saying the court will decide these issues we are raising. We are being heard on Thursday in the Western Cape High Court. That's the first issue. So there won't be undue delay or uncertainty as to when we'll get answers. Secondly, there is no response to what we're suggesting, that there has been no finding by any court. In fact, even in that urgent application, there were no reasons given, just an order, which says nothing about the merits of what we're saying, and that will be heard on Thursday. Lastly, Chairperson, and I can assure you now, these proceedings will not get anywhere, because unlike the last instance, we accepted the Hansard as presented. We will not accept it this time. Why? Because there's a difference this time. The last time the Hansard was a proper reflection of what happened on the videos. We watch the video and read the Hansard. There are many, many instances, and if you take us there, we'll take you there, where we show you that the Hansard does not reflect some of the statements in the House. For example, the speech by the Deputy President, it's not there. And there were interruptions and interjections during that speech. That is just one example of many, where in some instances, members of the ANC raise points of order without being acknowledged by the Speaker. They are not reflected in the Hansard.
Thank you,
And
Advocate.
so I'm
We
saying
take
in
it
short,
at that point. We
I'll
take
leave
it
it
at that point, yes.
Thank you, Chairperson.
Honorable members, this is your time. Honorable Mlenzana, your hand is up.
Chair.
Yes, thanks, Chairperson. Thanks, Chairperson.
Hello.
And
Hello, Chair.
Yes, you have the platform.
Is that an order now?
No, Ntate Mlenzana, you can speak.
Okay, thanks, Chairperson. Thanks for allowing. Thanks, Chairperson, for allowing us to come in. If you would have noticed, Chairperson, when I actually allowed the learned person from the side of the affected members to come in, I deliberately had a choice of words, particularly when it came to the word deliberation. I was careful to say, let's allow the presentation save deliberation, which I now come in to actually caution the session that let's avoid falling into a trap of seeing ourselves now going back to what we had dealt with in December. There's an echo, Chairperson. I don't know from which side, but I will continue. My view, Chairperson, and the session is that this is not worth deliberation. We had allowed the 10-minute presentation, of course, as a way of procedural fairness. However, the contents and of facts, as correctly put by the initiator, were perfectly rebutted, and now we cannot and we shouldn't reopen the same here and now. That's my take, Chair. That let's take that as noted, but not as a way of hip-hopping or stopping us from continuing with these hearings. That's my suggestion, Chair, that let's continue. Of course, we've noted that, but not for this hearing. Let's continue. That's my view, Chairperson.
Thank you, Honorable Mlenzana. Honorable members, if it's possible, can we switch off the mic in the room because it's making an echo. Honorable Ndlozi?
Sorry, Chair. I'm sorry for interrupting. Advocate Colin wanted to say something to assist the process.
So, thank you, Chair. Just very briefly, just a matter of procedure. Is the committee now deliberating the in-limine points? If that is the case, can I then ask, and I'm sure my learned friend won't object, so that the proceedings then stand down to allow the committee to deliberate, to come back with a ruling?
Okay. Thanks for the assistance, Honorable.
Can I raise an order? Can I raise an order, Chairperson, if you allow me? Mlenzana.
Yes. Honorable Mlenzana.
Thanks for that. I am now coming with a point of order. Chairperson, there is nowhere where as the committee we have opened space for deliberations. That is the order. Thanks.
All right. Thanks, Honorable Mlenzana. Order sustained. Can we then request Honorable Ndlozi?
Thanks, Chairperson. Chairperson, I do think it is procedurally fair. We must stand down and then excuse everyone else so that the committee applies itself to the arguments that have been put forward, takes a decision, comes back to communicate it. It's only fair. I'm not sure why we would procedurally not do that. We have done it before and it is only fair. So before I make my stake, I think we should proceed in that manner. And I'm not sure, but maybe you can address me on this point. Thanks very much.
Thanks, Honorable Ndlozi. Honorable members, this matter has been raised before, and I don't know if there's any adverse issues that we would want to raise in the absence of the legal teams, both legal teams, or what impact will it have on the procedures? Hence, I'm saying you are here, you can deliberate so that we deal with this matter here and now.
Chair, our Hands are raised.
Yes, Honorable Nhlanhla.
Thank you, Chair. Chair, I'm raising my hand to support Honorable Mlenzana. Like as the initiator had already alluded to the responses which our learned friend spoke of, that Chair, we allow the proceedings to proceed, the hearing to proceed. And also, Chair, that we must also raise that our learned friend was already engaging on the matters as though already responding to them. However, he wanted to insist that we have this hearing postponed as we await the court. So, which is not helpful. So, Chair, I'm raising my hand to support Honorable Mlenzana that this hearing must proceed. Thank you.
Thank you, Honorable Nhlanhla. I will go back to Honorable Ndlozi if you still want to make your points, Honorable Ndlozi. I know that we were talking to the issue of sitting down.
No, thanks very much, Chairperson. No, I agree with the submission of the affected members. As a matter of fact, the central natural justice concern here is why would we not allow the speaker to come and give testimony to the decisions that she made, both as a person that was there, but also essentially as a person that led the charges. So my submission is that we must allow that firstly. And I think that in relation to the affected honorable members, I agree fundamentally that there are the procedural concerns that have been raised must result into the immediate dismissal of the charges. So on those two scores, I'm in full agreement. Thanks.
Thanks, Honorable Ndlozi. Honorable Dlakude. Honorable Dlakude, I'm giving you the.
Thank you very much, Honorable Chair. Thank you very much. Honorable Chairperson, as we are already, I was hoping that maybe we will adjourn for a minute so that the committee can discuss on its own. But seeing that we are discussing now, let me get straight to the point. As we are sitting here, Honorable Chair, as a committee, there is no court interdict before us, so there is no need for the postponement until Thursday because there is a court judgment that is coming. That's my first point, of which I agree fully with what the initiator said. Secondly, Honorable Chair, this is a parliamentary process and not a judicial process, and we do not need an independent facilitator. I do have a trust in the capabilities of this committee to execute its duties fairly so. In the 2020 SONA matters, as we all know, against some EFF members, the very same committee, which is accused of being biased, unanimously agreed to drop all the charges because of lack of evidence. So I'm saying this because we are accused of being in our numbers as the ANC in this committee, while we are representing Parliament, of which the committee is a multi-party committee represented by parties of Parliament. So I just want to bring that before us so that we remember, we are reminded that this committee applies its mind when it does it, its work. So that's true. The other issue, Honorable Chairperson, in our previous hearings last year, yes, we couldn't find any evidence against Honorable Mente. Hence, she was not charged. Hence, she was not given any sanction. So she went scot-free because we couldn't find any evidence with regard to her case. So, Honorable Chair, this thing of being not being fair in this committee, because this committee numerically has many ANC members, is neither here nor there. Honorable Chair, we apply our minds, we deal with the facts that are before us, and the issue of calling the speaker to appear before this committee, we said it previously and we are still saying it. We have enough evidence before us to deal with these matters. So I submit, Honorable Chair. Thank you.
Thank you, Honorable Dlakuda. Honorable members, as you have deliberated, we will proceed with the agenda before us. We were at the stage where the acting chair has to put the charges for members to plead. I have indicated, honorable members, that I will recognize each member and request the member to plead to the charges. I will allow for up to 3 minutes for members wishing to give a plea explanation. I'll give them an opportunity to do so. If a member pleads guilty to the charges, I will ascertain from the member whether the member admits guilt to the charges as put to him by the initiator. If a member refuses to enter a plea, I must enter a plea of not guilty in respect of that member. I will start, honorable members, with Honorable Ntlangwini. Honorable Ntlangwini, how do you plead to the charges?
Thank you very much, House Chair. Chair, I plead not guilty to this concocted charges by the ANC government. I do not wish to make an explanation now at this point. I do reserve my right to do it at a later stage. Thank you.
Thank you, Honorable Ntlangwini. Honorable Matumba, how do you plead to the charges?
Thank you, Chair. Not guilty.
Thank you, Honorable Matumba. Honorable Mafanya, how do you plead to the charges? Is Honorable Mafanya on the platform? Oh, yes. Honorable Mafanya. You're not audible, Tate Mafanya. Honorable members, we just see on the screen, Honorable Mafanya's gadget is failing him. He's making gestures there. Not guilty. He's showing that gestures of down. Honorable Mafanya, I take that you pleading not guilty to these charges. He's agreeing. Thank you, Honorable Mafanya. Honorable Matulelwa, how do you plead to the charges?
I plead not guilty. And I wish to give an explanation at this point, and I reserve my right to do so at a later stage. Thank you.
Thank you, Honorable Matulelwa. Honorable Marais, how do you plead guilty to the charges?
Not guilty, Chairperson. Chairperson. Can you hear me?
Yes, ma'am. Yes, I can hear you, Honorable
Um,
Member.
Okay, I'm pleading not guilty, Chairperson, and I will reserve my right just to keep this for the later stage. I will give explanation at this point, and I reserve my right to do it at the later stage. Thank you, Chairperson.
Thank you, Honorable Marais. Honorable Chira, how do you plead guilty to the, how do you plead to the charges? Sorry.
Thank you, Chairperson. I plead not guilty. I don't wish to give an explanation at this point, and I reserve my right to do so at a later stage.
Thank you, Honorable Chira. Honorable Tambo, how do you plead to the charges? Honorable Tambo. Your mic is open, but there's no sound.
Chair,
Yes,
can I
ma'am.
suggest members who have difficulty, they can also write on the chat and then we can communicate that. Yeah,
Okay.
please.
I will go back to Honorable Tambo. Let me take Honorable Montwedi. Honorable Montwedi, how do you plead to the charges?
Thank you very much, Chairperson. I plead not guilty, and I do not wish to give an explanation at this point, and reserve my right to do so at a later stage. Thank you very much, Acting Chairperson.
Thank you, Honorable Montwedi.
Acting Chair, am I audible?
Yes, you are now, Ntate Tambo.
Yes, I plead not guilty and I do not wish to give an explanation at this point and reserve my right to do so at a later stage.
Thank you, Honorable Tambo. Honorable Leapo, how do you plead to the charges?
Thank you, Chairperson. I plead not guilty and I reserve my right to explain at a later stage. Thank you very much.
Thank you, Honorable Leapo. Honorable Mukonto, how do you plead to the charges?
Greetings, Chair, members of the committee and honorable members. Chair, I plead not guilty and I reserve my right to give an explanation at a later stage. Thank you.
Thank you, Honorable Mukonto. Honorable members, are there any members present who have not yet been asked to plead to the charges? Have I called out every member? I don't see any hands. It means all the affected members has pleaded to the charges. Honorable members, at this point, can I request that we take a comfort break? We were supposed to have that tea at 11:30 for 15 minutes. We are now at 4 minutes to 12. We will be back in 15 minutes.
Recording stopped.